Good morning, everyone, and welcome to WALGA and PSL joint webinar on managing workplace investigations. My name is Natalie Abend, and I'm one of the ER consultants in the WALGA Employee Relations team. I'm very excited to introduce Connor Fahey, Owner and Legal Practice Director at People Strategy Law, PSL, and Connor will be presenting today's webinar on workplace investigations. Connor has over 17 years of practice, specialising in employment law, HR and IR matters and ER matters, and has extensive experience conducting efficient and very effective workplace investigations, especially when they're very complex, sensitive, or tricky to manage. So Connor, and a lot of experience in the local government sector, working with local governments and assisting them with workplace investigations. And I'd also like to point out that PSL is on our preferred supplier panel as well. So we're very lucky and very grateful to have Connor joining us and sharing his valuable insights and expertise and talking all things workplace investigations with us today. So just a few housekeeping things before we get started today. So the presentation part of the webinar will be recorded and will be available on the subscription area of the website. So we will upload the presentation part of this webinar on our ER subscription area of the website in the next few days. But the Q&A section will not be recorded. So just please keep that in mind, that any questions asked today in the Q&A section won't be recorded. And also that hopefully allows you to also feel confident to ask any questions that you may have as well. So we would ask you please to type in any questions as they come up in the Q&A section. So you'll see there's a Q&A little icon on your screen. So if you click on the Q&A icon, you can type in your questions there and we will address those in our Q&A part of the webinar. And we do have time constraints today, so we're aiming for a 45-minute webinar. So if we don't get through all the questions, we will get back to you and follow with you up later on. And just a general disclaimer, the webinar is intended to be industrial relations information only. There's not legal advice. And if you do have any specific questions or need advice on your specific circumstances, we'd encourage you to always contact us, please. So to commence the webinar, we would like to do an acknowledgement of country and acknowledge the traditional owners. WALGA acknowledges the continuing connection of Aboriginal people to country, culture and community. We embrace the vast Aboriginal cultural diversity throughout WA, including Boorloo, Perth, on the land of the Whadjuk Noongar people, where WALGA is located, and we acknowledge and pay respects to our elders past and present. WALGA is committed to supporting the efforts of WA local governments and NT local governments to foster respectful partnerships and strengthen relationships with the local Aboriginal communities. Thank you. I'll now hand over to Connor, who will get started on the workplace investigations and tell us all things he knows about managing effective workplace investigations.
Thanks, Natalie. And hello, everyone. Firstly, very happy to have been invited to present to the sector on managing workplace investigations, an area of specialisation of PSL Legal and PSL Group. As the WALGA team know, and Natalie pointed out, fortunately, I've had a strong connection with the sector over the last 10 years, having advised and assisted many local governments over the years, potentially a few familiar faces in the attendee group. So hello all. I just need to start with and reaffirm the usual disclaimer. Today's presentation is providing information of a general commercial and industrial relations nature only and does not represent specialist, professional or legal advice. Appropriate specialist or legal advice should be sought for specific situations, and PSL Legal today provides the usual liability disclaimer as outlined in the screen there. Okay. To quickly outline what we intend to cover today, I just set out here a roadmap. We only have about 45 minutes, and as I think a lot of people would appreciate, this is a topic which some providers wish to cover in masterclasses over 4 or 5 days even. So what I'll be covering off today is mostly at a high level across the 4 sections here: receipt of grievance, then the investigating component, making findings, and then considerations around reports and post-investigations. And I intend to hopefully give a full 15 minutes towards the end to address questions and queries, get into a little bit more specific detail and examples, and maybe even share some war stories if we have time. Given the time limitation, I'm intending to work through a general best practice approach to workplace investigations, walking through what would normally represent my usual approach and considerations, noting that there are and can be some variations in approach to workplace investigations, and that the general approach that I'm going to set out here is not a one-size-fits-all. Investigation approaches can vary depending on the nature of the matter, but I intend to cover off, at least from a high level, some of the key considerations that really should be part of most investigation considerations, and the best way to progress those. The first step, or the first section of a workplace investigation, usually always starts with a complaint or grievance coming to the notice of mostly the HR practitioner or a relevant manager. Usually in local government, that might be via an email or a submission of a formal form. Sometimes that might be by way of a meeting, a formalised meeting or an informal meeting. However, I think it's important to note that while a lot of investigation matters have their genesis or start in some form of written or formalised grievance or complaint, it is not necessary for a workplace investigation to have to start with or be driven by a formalised written complaint by an individual employee. Because it is very valid to note that an investigation can be commenced without a formalised written complaint from an individual employee, because an organisation, the local government in itself, will have a right, and in some instances an obligation, to have to commence an investigation when the organisation becomes on notice of an issue. And that issue may come to the organisation's notice outside of or separate to a formal written complaint. So sometimes there's a bit of confusion that any workplace investigation must start via a formal written complaint of an employee. That's not necessarily or technically the case. If the organisation becomes aware of a matter which may require a workplace investigation, the organisation itself can commence that investigation without a written complaint from a formal complainant. In terms of progressing from whether it's a formal written complaint, a formalised complaint document, or something which an organisation has become on notice for, I strongly suggest, especially when I'm advising or interfacing around an investigation, from a very frank position, it's a reality that formal investigations can often be confronting, stressful, drawn out, a little bit abrasive for all parties involved. Therefore, it's often my starting point, and I suggest it's a starting point for most practitioners, to determine if there are any practical or pragmatic alternatives to a formal investigation that may be available to generate a solution to the issue. Now, it's important to note that there is a number of circumstances where an investigation might be necessary and required and alternatives can't be considered. For example, where allegations are particularly serious, where the allegations may result in serious disciplinary consequences that require a procedure of fair process, or relevant to local government industry matters which there is an obligation to have to investigate For example, there are certain safety issues and safety matters under occupational health and safety legislation that create an obligation to investigate. Or in local government, again, there's certain disclosable matters specific to local government under CCC legislation and public sector commission legislation that may require an investigation. So it's important to determine whether that threshold exists. But if it doesn't, I strongly suggest that where an organisation has an opportunity to consider alternatives to formalise workplace investigation, there is a little bit of time given by the HR or the manager who's overseeing the complaint to determine whether there are other alternatives to avoid the reality of a stressful, drawn out and abrasive situation that may not actually resolve anything. It's just maybe by way of a very kind of brief example, and all examples I provide are outside of local government, just to ensure that no one, watching this sort of is recalled of a circumstance in which I've been involved. But to give you a good example, is I was involved in a matter a few years ago where a organisation sought my advice and assistance to investigate very broad allegations of inappropriate interactions and bullying by a senior manager. But the actual complaints were relatively vague. No one could actually articulate anything specific. It was a bit of a vibe of the approach of this manager. And it was my view at the time to say, well, what is like the likely outcome of commencing a formalised investigation is that we might not be able to get sufficient information and particular instances of misconduct to investigate. And therefore, there will be a process which has been formalised, but the outcome will not result in anything except for me as the investigator being paid for services, but an outcome being no finding because the allegations weren't sufficiently particularised. So what I suggested was that rather than commencing a formalised investigation process, that the organisation consider a cultural review, which was everyone in the department was confidentially provided an opportunity to provide some feedback. That feedback was collated, and then that department was provided a cultural review outcome. That leader had some confidential feedback in relation to some of the feedback of the cultural review and allowed that leader to be provided targeted training around leadership and development, and actually resolved all the issues within 6 months. So there was an avoidance of a formalised investigation process, which would not have likely resulted in any benefit, whereas an alternative of a cultural review facilitated the team being heard about their grievances and concerns confidentially, and then the leader being able to be enabled to succeed with the team moving forward. So it's just a simple example of alternatives. Another one which is well known is things like mediation. If there's a likely potential that the parties can come together in a mediated setting rather than through a formalised investigation, that's something worth considering. Also, potentially if a matter is of a lower level of seriousness and a full formalised investigation might not be needed, it might be under advisement, it might be an option available to progress through a more informal disciplinary interface rather than needing a full formal investigation. However, if we assume that a matter does require investigation and the alternatives might not be suitable, or the alternatives weren't successful and investigation is required, there's also relevant considerations as to whom should undertake the investigation. So there are a number of options of how to have an investigation undertaken, whether it's undertaken in-house by an in-house HR team or in-house by internal practitioners, and ensuring that those who undertake the investigation are sufficiently independent to the matter that's being investigated. However, sometimes it might be worthwhile considering that a matter is of a particular level of seriousness, or there is a requirement that someone sufficiently independent is brought in to undertake an investigation. There's no right or wrong answer in relation to whether an investigation should be done internally or externally. However, from a loose consideration, if the matter has levels of complexity, legal complexity, technical complexity, or there are considerations that a report might be part of a future legal issue or dispute issue, then they are considerations that are worthwhile balancing as to whether a matter is undertaken internally or whether an external person is engaged. Pros and cons, pros of external investigating is that you've got someone who's usually specialised in investigating and will bring a lot of skills and knowledge in how to progress a process correctly and obtain the right outcome. The next one is generally independence. That person is engaged is essentially independent of a matter. They just come in and are engaged to make a finding in relation to the issues, usually separate to any of the internal politics considerations that might sometimes influence an internal person undertaking an investigation. However, the cons are cost. The external investigators are a cost, and investigations usually are time bound. They're not swift. They sometimes can take a lot of time, and it's usually time that increases costs. Also, the bringing in of an external investigator sometimes can be a little bit confronting to parties, where if a matter is of a lower level or there is sort of cultural sensitivities in the organisation, bringing in an external person can seem quite confronting, and that can have cultural flow-on effects. So again, it's worthwhile considering pros and cons of an external investigator. Another relevant consideration, I'm not going to go into too much detail about this, but it is something that comes up in the decision as to whether to internally or externally engage an investigator, is the concept of legal professional privilege. Legal professional privilege, for those who might not have come across it, is generally, a simple way of putting it is when an organisation obtains advice or requires information for the purposes of progressing a litigation matter or a matter in court, information which is created and shared where there is a legal practitioner that is providing that advice for the purposes of legal advice or litigation, then that information becomes what's called legally professionally privileged and does not need to be shared or cannot be compelled to be shared in a court process. That can be useful in workplace investigations as a concept where the investigation may result, the outcome of the investigation may result in a matter which may be litigated, for example, dismissal type litigations or workers' compensation type litigations. Now, a workplace investigation conducted by a legal practitioner will not necessarily automatically become legally professionally privileged. There is a process that is required to be undertaken to ensure that the obtaining of an investigation report holds legal professional privilege. Rather than spending a lot of time on that concept, I'll just flag it as a relevant consideration, and the key takeaway would be if a matter holds likely legal risk or potential industrial risk or workers' compensation risk to an organisation, it may be worth considering whether the matter needs to be commenced, investigation now needs to be commenced under legal professional privilege. And if so, then there will generally be a commencing process to ensure that any investigation process and following report holds and maintains legal professional privilege. Okay, so once the mode of investigating has been decided, whether it's independent or it's internal, external, underprivileged, etc., I usually always strongly suggest that before commencing an investigation, that there is a planning phase undertaken. Look, and this is just general pragmatic practical planning, but it's just useful to set some timeframes and some considerations as to what are the likely steps that will come. And it also provides an opportunity for setting up or giving a bit of time to think about things like whether professional privilege is needed, who's around, who are the potential witnesses, how is it that the organisation is going to commence its process. Very usefully, WALGA has some template documents which I believe all subscribers have access to, and within those documents there is some very clear processes in which to set up and investigation planning process. So rather than going into a lot of detail here, I'll just flag that they're available, and they're a really great resource to be able to use for starting those processes, or at least becoming conscious of what's required. In the planning phase, one of the tips, or one of the things I want to flag is make sure whoever is managing the investigation, whether it be a HR practitioner or a leader, people leader, that the organisation, local government, turns its mind to any policy or industrial instrument that might apply. Because sometimes company policies, local government policies, and or industrial instruments, enterprise agreements, hold within them particular process requirements for undertaking and workplace investigation. So during the planning phase, it is very worthwhile to canvass the technical requirements of any policy or process and ensure that you're complying, because you don't want to get to a situation, and as an external investigator, this can sometimes be a bit frustrating, where a process has been started and then at the 11th hour there is a flag that there's a non-compliant technical, which might require some backtracking of process. So yeah, that's just a sort of tip there to make sure that all relevant company policies are considered before or in the planning phase. That said, it is generally the case that most organisations' investigation processes provide a grievance process, but there's usually some discretion around how an investigation is actually undertaken. So often that discretion will be relied upon to enable decisions about how an investigation will be undertaken. There is often a preliminary instigation point that an organisation or local government needs to take when starting day one of a workplace investigation process. One is defining a scope of an investigation. So often there will be a complaint matter, which I flagged at the start. There'll be an individual who has logged a complaint, flagged a complaint. That complaint will then commence an investigation process. It is very useful for an organisation in the planning phase, and especially if engaging an external investigator, to create a scope or what I call 4 walls of what is intended to be investigated. Because essentially, when you start the investigation, it's beneficial to try and create a scope of what is intended to be investigated to prevent allegations that an investigation matter is a fishing expedition, that you've been put on notice of something small and then an investigation has been started to try and find every single thing that's wrong. Generally, that is not a good approach for a workplace investigation. So you want to scope what it is that's being investigated from the outset. The second is to scope an investigation prevents an investigation becoming bigger than Ben-Hur. So what that means is, as you go down a track, then there are other things that keep getting brought in, and then what was first intended to be investigated as something quite discrete becomes 20, 30, 40, 50 issues, and you've got 6 months worth of investigating to go. So if you generate a scope, a box, a framework for the investigation at the start, that can prevent those issues occurring. Also, by way of my practice, I strongly suggest that an investigation in scoping is done in a 2-part structure, where part 1 of a scope is to undertake what's called a fact-finding and particularisation process, which is what is the complaint and what is exactly the specifics of what is being alleged. And then part 2 is then investigating what has been particularised, or investigating the specific details that have been determined as part of that step 1. That prevents allegations of fishing expeditions, and it prevents issues becoming bigger than Ben-Hur, but also gives a nice structure to a workplace investigation process. So in the slide, we've got the preliminary investigation and particularisation phase, which is that part 1 that I identified. Essentially, usually that will start with a document review, any written grievance, any relevant emails, any documents that can be obtained that relate to the issue that's being investigated. And then following that, usually it's an interview with the complainant, the person who has made the complaint. Or if there's no actual complainant, and this is an investigation in which the organisation has commenced, usually that step is speaking to the relevant central parties to determine what is the details around what has been alleged. Often then there may be a requirement to extend that out to speaking to relevant witnesses, just so that there is a complete understanding with enough details of what it is that's being alleged and enough background information from documents, witnesses and complainants to say, this is what we understand is the relevant information and relevant background and relevant particulars or specifics of what is being alleged. The next process I would ordinarily undertake is what's called a particularization exercise, which is really saying, let's get the key details, the key components, the key background, the key outline of what it is that's being alleged, and draft that up in a way that has the right amount of detail and the right amount of information for somebody to receive, understand what is being alleged, and to be able to respond to it. It is a key tip that I suggest is that when you are doing that particularizing process, that the organisation also draw into the particulars any specific elements of a employment contract or policy which are potentially breached, so that you can create a link in a single document between the relevant background information, what is being alleged, and any relevant policy or contract terms that relate to that allegation. This process is really useful because it really sets up procedural fairness to allow a respondent, the person who has the allegations made against them, to be able to fully understand what is being alleged and fully respond, and can't therefore subsequently say, I didn't know what was being alleged, I was put on the spot, I was put into a corner, I didn't know what I needed, what I was being alleged against me. You've set up the process in which it's very clear and very clearly outlined, and all the information has been provided for that individual to be able to fully respond. So therefore, then an investigator can then make decisions on the basis of being provided all the information. There's an interesting question here about how soon do you put a respondent on notice of an allegation. Now, there's no hard and fast rule of that. Sometimes the practice would be that a person who has had an allegation made against them is informed at the time that the investigation process starts. So often that might be a correspondence to say, dear X, an allegation has been made. The details of this will come to you in a short period of time, but we're letting you know. And another very relevant consideration at that juncture is whether there is a need for a stand down or some kind of immediate intervention. There's no hard and fast rule about a stand down. And for people who might not be aware, a stand down is where during the investigation process, the person who has had the allegations made against them is directed to not engage in work. The reasons for determining whether a stand down is required at the commencement of an investigation will usually depend on the seriousness of the allegation, the likelihood of that person having impact or influence over others during the investigation process, and or whether there are any other duties that the organisation have to ensure that there's no other future harm by that person. I would suggest potentially providing specific advice if and when questions about stand down arise in and around an investigation, because that can be a technical issue that causes issues down the track. But just to flag that is often part of the planning process, the workplace investigation. When there is sufficient particularization of an allegation, then generally the next step is to, from a practitioner's perspective, I will usually obtain an instruction from the local government to say, those particulars are what you are instructed to investigate. Please commence your investigation and make findings on those particulars. If you're doing it internally, that is just a case of setting out to the respondent what it is that's being investigated. It is important as a function of particularization transitioning to response that the respondent or the person who needs to answer the allegations is provided in sufficient detail the allegations which are made against them. And that particularization process will have facilitated that. But another relevant consideration is that the person who needs to respond is given sufficient time in which they can consider what it is they need to respond to. How much time is very much dependent on the detail, seriousness, length of allegations. But simple would be more complicated, more detailed, and more serious. You would give someone more time, for example, a week. Again, no hard and fast rule, but as an example. Whereas if something is maybe a little bit less serious or a little bit more straightforward, it can be a shorter period of time for them to be able to prepare to provide a response. The provision of a response doesn't have to be by responsive interview. An organisation might see that it is fit and proper for the response to be provided in a written form, and that's fine. By way of my process, I usually always suggest responsive interviews in person or by Teams if that's a better process logistically. Because even though a written response can be provided, that can be really useful, sometimes there is a lot of utility in speaking to, testing and assessing a response. And I'll get to one of the very key components of that now. So usually it would be my process to run through particulars, obtain a response to each. An important part of procedural fairness of responsive interviews is to ensure that each allegation is actually responded to. So sometimes that would be a case of actually asking a clear question, do you admit, deny a particular component? So that then you are certain that you've asked and they have responded. But another very important component of an investigation is what's called testing conflicts of evidence. This is where you might have evidence from one person as an investigator, and now you have evidence of the respondent and they differ somehow. By way of procedural fairness, it would normally be common and proper to allow a respondent to be informed or inform the respondent that there exists differences of evidence and bring to their attention that conflict of evidence and obtain their response to that conflict. Simply saying, you have said that you deny this. This person said that they observed this. I have two pieces of evidence here. Can you explain to me why there would be a difference? That is putting someone on notice of conflicts of evidence. It's often very important, and that is difficult to do on the papers only. That is a question that is usually better asked in the interview. When a response is obtained and the responsive interview is finalised, usually there is an assessment as to whether there is sufficient information to be able to make a finding. So my process is to create what's called an evidence matrix, which goes against each piece of evidence that's been provided and determine whether a finding can be found on the balanced probabilities. I'll talk about that in the next slide, against each of the particulars. If there are big question marks or further gaps that need to be filled, that's when the investigation will go to a further investigation phase. So are there any further witnesses? Are there other further documents? Or are there just questions that can or can't be answered? And that would be the requirement to undertake a further investigation phase before findings are made. When an investigator has deemed that they have taken all reasonable steps to be able to obtain all relevant information and allowed a respondent to respond to all relevant information that might land on a finding and relevant conflicts of evidence, then an investigator can say, on all the information I have available to me, I can progress to making a finding. And this is where there will be a collation of evidence and a consideration as to what the findings are. And I'll just move on to the next slide to talk about making findings. So an assumption that an investigator says, I've basically taken all the steps that I can to obtain all the information I can, transition into the opportunity to make findings. Now, it's important to note that workplace investigations, there are two very important considerations in making findings. First is that a finding in a workplace investigation can be made on the civil standard of proof, on the balance of probabilities. Essentially what that means is, take a seesaw, is it more probable than not, on the information that I have in front of me as the investigator, that the allegation or the particular occurred or not occurred? Okay. It is not the criminal standard of proof of beyond reasonable doubt. It is not the case that, if there is doubt, you cannot find. It is that weighing up the information that I have, is it more probable or less probable that the allegation occurred. That gives an element of leeway and broader decision making, but a secondary principle that's very, very relevant is what's called the Brigginshaw principle of standard of proof. Essentially what this means is where an allegation is more serious, the investigator must ensure that it relies on stronger evidence in order to make a finding on the balance probability. So very simply put, it's the more serious the allegation, the more you need to be convinced with probative evidence or more solid evidence in order to make a balance of probability finding. So if an investigation outcome maybe might result in termination of employment potentially, or escalation to an external body, then the Brigginshaw principle should be front and center of the making findings. In a very high level view on applying the Brigginshaw principle to the balance of probabilities, I've just listed here in the table below maybe some of the key considerations of how the Brigginshaw principle be applied. So if the allegation is of high level of gravity, then you would need to be ensuring that you're applying the Brigginshaw principle. Where the evidence is of high quality, so it is directly written documents, things that are factually very clear, then they are pieces of evidence that have high probability, or they're stronger pieces of evidence to rely on. The nature of the evidence, similar, how it came about. Is it very long time ago, or is it very fresh in time? Are there multiple parties that corroborate the same piece of evidence? Again, that is a stronger piece of evidence, more probative. However, or are there contradictions or inconsistencies? And where there's contradictions and inconsistencies, it is not the case that it is beyond reasonable doubt. It's just that where there might be contradictions or inconsistencies, then that strength of evidence is alleviated. You can assess the credibility of witnesses, which is often relevant where there's he said, she said, or two conflicting components. The next is how inherently unlikely is an issue to have occurred. And the last part with Brigginshaw is just to make sure that the decision maker or the investigation findings avoids inferences or assumptions in making its findings. So if there is an inference or assumption, sometimes at the standard of balance probabilities, an inference is allowed because it tips balance probabilities. Whereas if there is a Brigginshaw principle and a serious allegation, there really should be trying to avoid large steps in inference or large steps in assumptions to make a finding. Okay, so on the assumption that a finding is made, whether an allegation is substantiated or not substantiated, it will usually then be transmitted into a report. And the report will depend, the length and complexity of the report will often depend on the nature of the matter, whether it's an external issue, whether it's a serious matter, whether the report is likely to need to facilitate legal advice, whether the report is likely to be needed to defend a disciplinary outcome, for example. But I just want to clarify what an investigation report does, or what it's intended to do. An investigation report is really just a document which provides a factual outline of the relevant matters that have been found, identified, outlines whether certain particulars and allegations have been substantiated, provides that the process was procedurally fair, gives an outline of what considerations were used to make a finding. And sometimes that might include relevant observations, okay, if that's sort of relevant to the matter. But it's important to note that technically a workplace investigation report does not and will not include recommendations. Recommendations are something which follow the report. The investigation report may be used to inform recommendations, but it is my strong view, and from a defensibility perspective, that an investigation report is separate to recommendations. If an organisation and local government requires recommendations, they can obtain them, but it's just strongly suggested that they're done separate to the investigation report. To be able to show that the investigation report was a standalone process, and that recommendations came following the investigation findings. and that makes issues of defensibility of the report useful in the future. Relevantly as well, an investigation report really is there to inform and enable decisions that might flow from founded conduct. And very similarly, the decision maker, whether it be HR manager or CEO who needs to make a decision of potential consequence founded, can use the report. But again, it's probably strongly recommended that any advice about what should be done is separate to the report. So again, you get two separate documents informing the outcome. Lastly, when an investigation is finalised, notification of outcome. Who should be notified, when and how? That's a case-by-case question. Where an investigation is done under legal professional privilege, it is strongly recommended that only the party whom discipline will follow is notified, and there is a process in which they're notified. The reason that that's suggested is to ensure that no party outside privilege is provided a copy of the report to get rid of the privilege over the report. However, if there's no privilege, it would be common practice that the person who's made the complaint and obviously the respondent are notified, usually in very brief summary form, as to what the outcome is. It's relatively rare that the parties get a full copy of the full investigative report. Again, there is case-by-case determinations as to whether this is useful, but it would be a starting point to suggest no, not everyone gets a copy. That is the internal document of the HR or the decision makers to inform the outcome. It may be that a decision is made that a report is shared because that might be useful to inform of a outcome. We're making this disciplinary decision on the basis of this report. Here is a copy of the report. That can be useful, but it's not a first step recommendation that that's done. So again, I would suggest obtaining advice if and around a situation where who gets a report and when, because that will often be determined by what is the intended outcome of the document as it relates to the findings of the report. What happens if findings are challenged? I have to probably defer to internal policies. So some organisations do have a right of reply or challenge process. So you need to make sure that you're not that you're compliant with any internal challenge process. That said, it's relatively uncommon, but they do exist. It's generally not the process of an individual to be able to completely challenge a findings of a report. If a disciplinary outcome is implemented in a procedurally fair manner, then that person, as part of the response to the disciplinary outcome, can then challenge the findings of the report, and that will be considered separate to the investigation report itself. That's usually how that matter arises and is resolved if required. And I flagged the legal professional privilege over the report. Again, that's linked to what is the intended use of the report and the outcome. And I strongly suggest that advice is obtained if and when there's situations where that's live. That's a very high overview of the process, and I acknowledge that I've gone over time. I think I would like to still give the opportunity for questions and answers because there's a lot of value. So I might just hand back to Natalie to flag that. But thanks everyone for your time and patience during that overview.
Perfect. Thank you, guys. Just bear with me while I get settled in for one moment. Alrighty, so I'm just opening up the questions now, and I can see that's great, Connor. Thank you so much for all your knowledge and expertise and the valuable discussion Q&A part at the end. I think people had quite some really interesting questions there, especially around witnesses and that whole process. It's been really insightful, and I found it really insightful. I'm sure everyone else listening has lots of tips in there and lots of guidance that LGs can take away to make sure, they know what to do when conducting the investigation and also who to get in touch with. So just a reminder that, Connor and PSL, is on our preferred supplier panel. And we would strongly recommend getting in touch with Connor if you're ever faced with the need to do a quite complex investigation where, there's lots of difficult allegations you need to deal with, or if it's very sensitive, maybe the allegation involves quite senior employees at the local government, or it's just a very sensitive nature of allegations. We've got bullying or sexual harassment, they're really serious and tricky ones. We definitely recommend contacting Connor for his assistance, and he'll be able to help you through that process. And thank you everyone for listening in to our webinar today. We do really appreciate you taking the time to stay online with us and listen throughout the webinar. I'm sorry that it has gone over time if you've got other commitments. And we'd just like to plug that we do have an ER guide on workplace investigations and some template documents, which can help you out. And that's only for subscribers. Everyone joining here is a subscriber, so you just need to log into that locked section of the website to access those. And also, we'll just probably point out as well that we obviously also have our 1300 number and our ER email address, which I'm sure you're all familiar with. And on the screen there is the list of our lovely team members in the ER team. So if you call up, you'll get one of us on the phone. We send an email, one of us will respond to you. And just also another last plug is that we do have another webinar coming up on the 29th of November on sexual harassment, which will be looking at the new positive duty on employers to prevent sexual harassment and sex-based discrimination and harassment as well. So we will send out an ER alert with the registration link for that webinar in the next few days. And we will also have another guest speaker joining us from Kingston Reid to present that one. So that will be on the 29th of November. So thank you everyone for joining in. And once again, a reminder that, Connor is on our preferred supplier panel, so you can contact him if you ever need to about workplace investigations. And, if you need assistance with your other IR, HR matters, you've got the Walga ER team to get in touch with. Thank you, everyone. Thanks for joining in. Bye.